they ask you these things, but I mean, for the most part, most of us, and I'm not blaming restaurants or pointing the finger. I think all of us do this. We have no idea half the things that we're consuming because there's all sorts of ingredients in the ingredients. Hello, and welcome to the next episode of Beneath the Law. You're here with Gavin Ty and my good friend, good buddy, partner, and co-author, Stephen Teal.
Thank you, Gavin, and a nice plug for the defamation book that just got published. Well done.
That's right. We are the proud authors of the Practical Guide to the Law of Defamation, along with our co-author, James Cook. And Stephen, congratulations to you. Thanks very much. And so buy that in your nearest LexisNexis outlet. It makes riveting reading. If you're having trouble sleeping, you'll quite enjoy it. But it is a practical guide, as we say, to what is the law of defamation in Canada, which is obviously a fascinating area of the law and one that governs programs such as this. So, Stephen, we better be careful that we don't fall into the trap of defaming anybody here, even mythical creatures like Mickey Mouse.
I'm just here to express my opinion, and make fair comment.
Opinions reasonably held by others, I assure you. But in any event, we are going to talk about what is, I think, something that one of the things of people of our generation, the older elders. I don't know you, but when I was a kid, I can't remember anybody having really allergies. I suppose that they did, but you never had issues of, oh no, peanut free this or that. And I know when my own kids were going to school, it was a big deal. All of a sudden, it was like you had to be very careful that you bought anything you brought that you packed in your kids' lunches. My kids thankfully didn't have allergies, but they had to be very conscious of what we put in, they took to school in terms of treats or what have you, what you gave out at Halloween, because it had to be peanut free because some kids reacted very violently, and in the case we're going to talk about, in fact, this poor woman died.
Yeah,
she died as a result of an allergy to, I think it was peanuts in this case. So, this type of thing is real. It is a huge problem, and it is a big deal when you think about it. And I don't know about you, but I also noticed that never used to happen back in the good old days, or I don't know if they were good old days or not, but back in the old days, you never have a waiter come up and ask you after you made your order, anybody here have any allergies? Now you go to a restaurant, every single waiter asks you, do you have any allergies? And that's, I guess, what happened here.
Absolutely. And, this case that we're talking about, sorry if I cough every once in a while. I've got a bit of a cold here, Gavin, but...
hope it's not an allergy. You're getting over the cold I had, so yeah.
Yeah, no, well, I probably caught it from you last week, but...
Well, don't say I don't give you anything.
Just don't give me an allergy. I don't have any allergies either. I'm not sure what is the cause of the rampant allergies or the higher frequency of allergies in
I think basically back in the old days, allergic people were dead. That's why there weren't that many of them around. So,
well, I don't know. It might be more environmental issues today and other things. But anyway. This poor woman, attended at a restaurant at Disney Springs in Orlando. So Disney Springs, basically, for those who are unfamiliar with Disney World in Orlando, was once called Downtown Disney. So it is the downtown area of the theme park, and it has a entire host of shops. So it has Coca-Cola, other businesses are there, and she attended a restaurant called an Irish pub.
The Raglan Road.
And I think honestly, Gavin, I think I've eaten there at the
famous street in Dublin. Wonderful and great song called Raglan Road. But anyways, we digress.
Oh, and the food is great there, by the way. But so she asked about allergies and... not allergies, but about certain things in the food, nuts and dairy products.
That's important. Stop. I think this is critical in this case. First of all, one thing about this plaintiff, or this, unfortunately, the victim, the plaintiff is actually the estate, or her husband is the plaintiff, but she was a physician.
Yeah, she was a doctor.
Yeah, so and a very accomplished doctor, and she specifically asked if the meal that she was ordering, which was scallops and onion rings, not exactly fine Irish fare, but anyways, the scallop part might be. But the waiter guaranteed that it did not contain any ingredient that she was allergic to. Wow.
Yeah, onion rings certainly wouldn't. Well, I guess in my view, they certainly wouldn't have nuts in them.
Well, they're fried in oil. Was it peanut oil?
Who knows?
That's the kind of thing. I mean, when you were talking about does a meal that you order at a restaurant have an allergen in it? I mean, the meal that you order in the restaurant, just like the food you prepare at home, oftentimes many of the ingredients you don't even know what's in them. I mean, there's oil in everything. I mean, these are fried in oil. Was it peanut oil? Was there some peanut oil mixed in? I mean, presumably it could come into contact with that. And what are the ingredients in the ingredients? I would suspect that the waiter had no clue what was the ingredients in the ingredients with respect to this particular.
The waiter wouldn't have had any clue.
But he was going around guaranteeing.
The chef would have certainly had a clue.
I doubt they would even know. Have you read the back of the label of an oil or a frying oil bottle? I mean, it's got, there's about 15 things in it. So my point simply is that they ask you these things, but I mean, for the most part, most of us, and I'm not blaming restaurants or pointing the finger. I think all of us do this. We have no idea half the things that we're consuming because there's all sorts of ingredients in the ingredients.
No, and I agree with you. And the interesting thing about this case too, though, is, Gavin, that the doctor, aware of her allergy, had an EpiPen and she administered it. And notwithstanding the use of the EpiPen, she still died. So
just tragic.
This case obviously hasn't been resolved. So was the EpiPen faulty? Who knows? What will come out of it at the end of the day? Another interesting issue about the claim, and we're not going to focus on this. The damages seem to be a little bit light, in terms of what is being sought. So I'm not sure what quite happened there. I think the claim is something for $60,000, and wrongful death claim for a high-profile doctor, that doesn't seem to be right in terms of the damages amount to me. But again, this is Florida, so I don't know.
We can digress for a moment. Neither one of us are personal injury lawyers by specialty, but as a rule of thumb,
but I've seen those ads in Florida.
Yeah, well, there are a lot of them. Like you can't. Yeah, I mean, and it is the land of. If this claim was brought in New York, as I recall, but I could be wrong. But it's a U.S. case, and certainly personal injury awards are large in the U.S. at times. But one of the rules is it's cheaper to die if you're a defendant than than to live. I mean, one of the big components that you see, that's a bit of a pet peeve of mine in personal injury awards here in Canada, because I think people need that money because it relates to their future care costs. And that's, generally speaking, the big number, if you will, for somebody, let's say they suffer a traumatic brain injury and they're going to need, attendant care for the rest of their life. Somebody who's 25 years old might need someone, to look after them every day, 24 hours a day for the next 50 years. And that is not going to be cheap. So that's why you see these big numbers. It's not because, wow, they won the lottery. It's because they need the money. They need the money to look after themselves. So it's oftentimes, from a defendant's perspective, cheaper if the plaintiff dies. As cruel and evil as that may sound, that's one of the reasons, in my view.
Well, but still, I mean, the wrongful death claim still includes a loss of income. So the number just doesn't look right to me. But anyway, it's
a
not
very limited claim.
Yeah.
And it's surprising to me. I mean, we're going from media reports, and we haven't read the pleading, but it is surprising to me that we really get to the real nub of the issue where this took a real twist and got some attention. as bad as the underlying facts are, where it got attention was basically a question of procedure. How are we going to litigate this?
Because the plaintiff didn't just sue the restaurant; they sued Disney itself and Disney parks.
Right.
The allegation is that Disney had control over the restaurant and the entire policies at Disney Springs. I find that, Gavin, quite frankly, a little odd because there are brand name shops in Disney Springs. And so I'm not sure in terms of, the control of the restaurant. Just seems odd to me that because there are a lot of independent and also brand styled restaurants there at Disney Springs. So I would have thought that it would have been a regular, ordinary landlord-tenant kind of lease. But regardless, they sued Disney, and Disney obviously didn't take kindly to being sued, and tried to rely on terms in, I guess I'm going to call them collateral contracts, saying that the case should have gone to arbitration. Which,
well, yeah, let's talk about that. So
is really what we want to talk about.
Yeah, so this is where let's just sort of backtrack. So we've got this horrible incident, very sympathetic plaintiff on the facts as they are sort of set out by the plaintiff. I mean, who knows? The ultimate facts aren't determined. It would seem to me a very strong case on liability, given the actual active guaranteeing of the ingredients being allergen free. That turns out to be untrue. It's a misrepresentation, which leads to actually fatal consequences. It would seem that case was a very, very strong case. Now, we tie that into what the plaintiff does. Is the plaintiff is the husband, sues for the death of his wife. He sues in civil court in, I think it's the state of New York, but I could be wrong. Anyways, he sues in a civil court. He seeks a jury trial, which is, of course, as you know, a very is the rule basically in the United States, not so much in Canada, but it is far more discretionary in Canada to get a civil jury trial. But in the United States, you have a right to a jury in a civil case, and he wants a jury. And it would have been, I expect, it would have played on to the sympathies of a jury. It's, as I said, the facts are bad for the defendants. And as you mentioned, the amount of money they're seeking was pretty small for a jury trial. But anyways, that's neither here nor there. He sues everybody. I, too, have difficulty with understanding the legal hook, if you will, to get Disney in on it. Disney would, if they are the landlord, I don't know what the obligation of a landlord would be to supervise the ingredients in a tenant restaurant's meals. I don't know what vicarious liability a landlord could have for a waiter of a tenant. But anyways, suffice it to say, the plaintiff thought it was a good idea, so they did. They sued them. Disney responds by saying, no, you can't sue us in civil court because years ago you clicked a box on Disney Plus when you were subscribing for like through watching reruns of the Mickey Mouse show or something, and when you clicked I agree on the box, you agreed that any dispute between us will go to binding private arbitration. In other words, you can't sue us in court. You got to go to arbitration. It's not that you can't sue us. It's just where and how. And private arbitration, most of our listeners will know this, but private arbitration are basically any private facilities that solve disputes. And I love giving this example because everybody understands it. But when you watch something like the People's Court is actually an arbitration. What the parties agree, they've got these stupid disputes over, he stole my tennis shoe or something. And the People's Court goes and finds these silly cases. And then they go to the parties, hey, if we got a deal for you, you can come up in front of, Judge Wapner or Judge Judy or whoever you want, sign this arbitration agreement, take your case out of the court system and put it before this private arbitration panel. So the People's Court is not a court at all. It's actually an arbitral tribunal, which is in Ontario and Canada, and certainly in most of the world, very, very common in terms of the resolution of commercial disputes. And if you read, which most people don't, any of those internet agreements that we all click, I do it. We're lawyers. I do it all the time. I agree. You may be agreeing to a lot more than you think you bargained for. I think you could probably I haven't yet to meet anybody who actually sits down and reads through those agreements before they click them. And we do it dozens of times, a day, all the time when you're using things. So there was an arbitration clause there that said all disputes will be arbitrated. You can't go to court. So Disney, I think they brought a motion to strike the claim and traverse it to arbitration. And that's what brought this case to the fore in terms of media attention.
Yeah, it brought it to the attention of the public. He actually, I guess, there was a second account that I guess the husband had signed up for some purchasing of the tickets at the theme park. And the backlash against Disney was very loud. And I recall when you and I heard about it, it absolutely made no sense that it was, I'm going to call it for what it is, and please don't sue me for defamation, but it was an absurd argument, in my view, which I think you and I both shared, that how could a streaming contract cause in a personal injury case, in the death of the gentleman's wife here, that should be going to arbitration rather than being heard in the court. So how would that contract even apply to those circumstances? And it made absolutely no sense. I think it was quite a remarkable argument that lawyers at Disney were trying to put forward, and quite frankly, if I was Disney, I'd actually fire those guys.
Just backing up for a moment, I agree with you, of course, that it was a stretch to try to bring this forward. It was
a rubber man stretch.
It was a public relations disaster, which leads you to sometimes lawyers, unfortunately, are guilty of myopic thinking and fail to understand that even though there are arguments that you can make and arguments that you should make, and this definitely fell into the argument that they could make, but they shouldn't make, because it was what this did, as I mentioned, is it created this story, which hit the news cycle, I think, all over North America, certainly. And it brought this whole issue about Disney, about this woman getting literally poisoned at a restaurant in Disneyland, to the fore, which frankly nobody had heard about. I had never heard about it. Those facts came forward just because they decided to try to enforce the arbitration clause. I mean, you might ask yourself, and I ask myself, what do they care? What difference does it make? You're gonna litigate the dispute. You litigate it. Sometimes there's great advantages to litigating in an arbitration because it gets heard. I mean, one of the big advantages to an arbitration is that it's quick. I mean, you can get an arbitration, a matter arbitrated within a matter of months. You're stuck in the court system, certainly here in Ontario, and I'm assuming it's the same in the U.S. I mean, you're talking about years and years and years of litigation before you actually get to a trial. So oftentimes, arbitration is a far more streamlined process. The problem is it ain't free. And I think that a lot of these arbitration clauses are put in by large multinational companies. I know Google had a case in Canada like this. They put these in not in order to expedite it, but to put a barrier toward people being able to bring them to task with respect to issues, because you got to pay. One of the things about arbitrators, Judge Wapner excluded, well, he's paid by somebody, but usually in arbitration, the parties pay for the arbitrator. And so the first thing you do in an arbitration, generally speaking, is write a check. And that is a serious impediment to an individual plaintiff like this.
Well, you're right. It's an access to justice issue. I think as well, one of the key things from a large corporation, arbitrations are not litigated in public.
No, that's why companies love them. Partially, one of the reasons why they're
it's just another
private
reason.
and the awards are private. Although
exactly,
yeah, so nobody knows what happened.
It doesn't create a precedent.
Right. There's no public record. You're bound by confidentiality requirements of the arbitration, which would not, of course, is antithetical to the open court system in the general systems of justice, both here and in the United States. So that is a big reason why many companies insist on arbitration.
Right, and your other point, it's really an access to justice issue, because most of these arbitration provisions are now found, as you say, in they're found in consumer contracts where you're buying a service, you click I agree, or it's not even a click box, it's just part of the agreement, and when you then have a complaint, the corporation comes back and says, well, you have to follow our arbitration procedure.
Right.
And all of a sudden, the consumer is surprised that's the case. And as you say, there are a number of cases in Canada that have looked at these kinds of agreements, whether they are arbitration provisions or jurisdiction clauses as well.
Right.
The courts have looked at these, and in my view, I think all of these kinds of provisions, particularly in the consumer context, are not enforceable.
Because they have been enforced. Why do you say they're not enforceable?
Well, they have been enforced and they have not been enforced, right? So there are cases that kind of go both ways.
Right.
Yeah,
no, for sure. And there are various types of contracts and various types of contracts. I mean, we're talking about this in the context of reality. And you and I both know, and the reality of it is that these multi-page contracts that you click on when you're getting an app or whatever, nobody reads them. And the judge knows nobody reads them. And it would be inherently unjust, frankly, to specifically enforce the terms of an agreement that nobody ever actually agreed to because they never turned their mind to it. Now, I'm not telling people not to read contracts. Read your contracts. I think that a lot of people would be shocked and amazed at what they've actually agreed to or purported to agree to. But those are, standard form contracts. I think that in the law, they're in these particular types of situations, they are contracts of adhesion. They're basically like, this is the deal, take it or leave it. And if you don't like, and we write the agreement, and obviously the party writing the agreement writes it in a way that is favorable to them. If I'm writing the contract, I'm not going to write clauses of the contract that I don't want. So that they write the contract. There's all sorts of contractual interpretation rules with respect to that. Contra preferentum is one of the such rule. In other words, that the writer of a contract will generally have the words read against them or read harshly against them if there's some ambiguity in the wording. So there are lots of rules like that, but I don't know that we can say that they are entirely unenforceable. I think that a court would look at the circumstances of the individual agreement and the circumstances of the parties and the fairness of the agreement in the usual context. But you got to get out from under the contract. So you start from a position where you're arguing that the contract doesn't apply, and even just to get to first base, so to speak, in your lawsuit. So I think that the people should be very wary about what they click.
Well, certainly, right. And I think that's the point, Gavin, that I'm making, that the context of the case is very important to these arbitration clauses that are in a contract. In a commercial contract, there would be, in my view, no doubt that kind of provision, whether it was read or not, would govern the jurisdiction of a dispute. But in the consumer context, as you say, it's a standard form contract. Nobody can really amend and strike that provision from the contract. In the employment context, more and more people are working for food delivery services like Skip the Dishes, and they're required to click on to these standard form agreements to ride the bikes around and deliver food. And there was a case in Manitoba Court of Appeal involving Skip the Dishes, where the worker basically wanted to be an employee rather than an independent contractor. And the agreement contained a mandatory arbitration clause that the worker, she didn't want to adhere to that, was required to accept it. And the court used a doctrine called the doctrine of unconscionability, which is very standard, and the court found that the provision was unconscionable because Skip the Dishes was in a greater position of strength, bargaining power. It was an improvident bargain to the plaintiff because she wanted to go to court and get a declaration, and was the weaker party and was vulnerable to Skip the Dishes because here we are in an employment context. The person just wants to work and earn some money, and you're forcing that person into a jurisdiction and a mandatory arbitration, which costs money, which the worker can't afford.
Yeah, I have a lot of sympathy for those types of things, but I also think that, courts have to be wary in terms of getting too far into rewriting the agreement between the parties. I mean, the reality of that situation, I mean, they would see this, similar, not similar, but analogous claims are being made, as I understand it, to unionize, for example. I read somewhere that Uber was facing an attempt to be unionized, which would mean that all of the Uber drivers are employees, and that is just their position is no, that's not our model. You don't work. We are purely a contract service, and some people like it and some people don't. I mean, I guess the option is don't be an Uber driver, you don't have to. No one's forcing you to do that. I mean, I appreciate that people need to make money and they're trying to make money, but I think it's always troubling when courts try to rewrite the agreement to give what they think is fair after the fact arrangement to who they consider to be the weaker party in the agreement. Because frankly, if Uber in that situation or in your Skip the Dishes situation, would they have they set their business up in a certain way? They have certain, they have stakeholders that invested or what have you in that business, and as it's set up in that model, all of a sudden they've got a whole rack of liabilities to employees for notice, for withholding from a tax perspective. What do you deal with? How do you deal with that? Do they have a duty to withhold and remit their taxes? I mean, that I can imagine you'd have a lot of screaming from the people providing those services if all of a sudden they saw 30 or 40% of their pay being remitted to CRA by the service. So, I mean, there's all sorts of permutations to that.
Well, I think, in terms of what you're saying there, the big issue is a lot of these apps and programs and business models that have been created really fall outside of outside of government regulation at this point in time. And, are they trying to take advantage of a system or a loophole in the system to do something that we view in a non-electronic world as shifting the paradigm and the power and the relationships between, in that circumstance, the Skip the Dishes, between employment rights and what would be, what is a true independent contractor. And there are cases on that very issue. When is a person an independent contractor versus when are they an employee?
And a lot of them are tax cases too. So
right, a lot of them are tax cases,
right.
But they're labor relation board cases or employment standard boards cases because if you are an employee, there are certain advantages to that in terms of employment standards legislation, tax issues. Pension plan issues and remittances and all those kinds of things. Whereas if you're an independent contractor, you're responsible for all of that. But we have these business models that have been created because of technology that really government is hard pressed sometimes to catch up to. And so then these issues land in the court, and the court being required to apply the law as it's developed to these new applications.
Right, exactly. Technology has completely run ahead of, for sure, a regulation and the ability to regulate. Technology knows no borders to a large extent, and we still live in a world where we are regulated geographically by, governments of particular jurisdictions. So, just leaping back to our tragic case of the very sad situation from Disneyland. We're never going to know if that clause was enforceable or not, because
Likely not.
No, because they withdrew the motion. They agreed to they withdrew their motion to strike the claim and move it to arbitration because and probably fired their lawyer because the PR department at Disney said, "What have you done? You've created a monster. If we don't let you have your jury trial." So it remained. They did not seek to enforce the arbitration clause. Having brought the motion, they abandoned the motion, as I understand it. So there's never been a decision on that. I think I think that they probably would have lost, but that's neither here nor there. We'll never know. And the lesson to be learned is, as we wind down this episode, careful what you click, because those agreements that we all like breathe, get me to the I agree. I can't get there fast enough. I scroll like lightning through those things, but silly thing to do, because you will face a situation where even if that agreement is not enforceable, if you end up in a dispute, you may end up trying to get out from under it as step number one in any lawsuit that you may be bringing as against the provider of the service and or, in this case, the restaurateur. So, Stephen, I think that brings us to the end of this particular episode of Beneath the Law, the tragic, and be careful what you order and be careful what you click. So once again, thanks for listening and thanks for tuning in. Please tell your friends if you have some, and be careful. Whether we will not defame anybody on this episode, hopefully. And buy the practical guide to the law of defamation in Canada, available at LexisNexis, just another shameless plug. And Stephen, always remember that if no one is above the law, everyone is beneath.
Including Mickey Mouse.